Hello, good afternoon, and welcome to the Law on the JoyNews channel. Information is important, and having access to information is crucial. It is for this reason that the Right to Information Law was passed to give expression to what the Constitution had already provided. Today on the law, we'll be having a discussion about Ghana's Right to Information regime. We'll be seeking to understand the bottlenecks from the angle of those who have tried to access information under the law, as well as hear from the Right to Information Commission. We'll be right back after the break. This is the law. I am Joseph Ackah-Blay. Joining me in the studio for today's discussion, I have with me Joseph Ackah-Blay. He is the Executive Secretary of the RTI Commission. Thank you so much for joining us.
Thank you so much for
I have a number of individuals on our Zoom platform. Evans Mensah is with the Fourth Estate, I can see. He'll be joining us. I also have Benjamin Boache of the African Center for Energy Policy. Manasseh Azuri-Awene, he is an investigative journalist also joining us on this important discussion. I want to start first with Manasseh, especially because he works with the Fourth Estate, and I don't think there is any single entity that has tried to access information under this particular law than the Fourth Estate. And Manasseh, first, I mean, in terms of trying to get access to information from various agencies, what has the experience been for you?
Well, Joseph, thanks for having me. It has been a mixed experience. I must say that prior to the coming into effect of the RTI law and even the commission, things were much more difficult than it is now. I'm saying this because in the past, if you requested information you were not given, you had very little to do. A few civil society organizations went to court in the past, but it is easier now than even going to court in the past.
Thank you.
So I must say that it is mixed. Mixed in the sense that sometimes you are lucky, and there are certain institutions that are a bit more responsive. I can mention the Ministry of Finance. I can mention the Ministry of Agric. I can also say that these ministries are, and a few others, are very responsive. The likelihood of you getting the information you're looking for is almost about 90%. I can also say there is another trend that depending on the information you're looking for, if it is information that is likely to expose wrongdoing, you find it very difficult to get it. And some of the most difficult places are the Ministry of Local Government and Redevelopment, the Ministry of Education. And I have a very difficult experience with the Ministry of Education when I tried to get information on the contracts, fumigation contracts, when COVID-19 struck. I wrote to this ministry in August 2020. And after a number of follow-ups and personal contacts, I got a response in August 2021. That was a year, 12 months afterwards. But that information was not even to give me what I was looking for. The ministry said, well, the contracts were, or that program was handled by a committee set up at the presidency. So I should go to the presidency. I wrote to the presidency, no response. A follow-up letter to the president, no response. And I petitioned the RTI Commission. It was then that I had a response that it was the Ghana Education Service and not the presidency that handled that contract. Mind you, at the time I was doing the follow-ups, I was aware that the Ministry of Education and Ghana Education Service were collaborating on some aspect of the information. But when this letter came, we even had letters from Osafo Mafo and then the Chief of Staff to the effect that our request had been referred to the Ghana Education Service. We followed up to the Ghana Education Service, and there was no response. And I wrote to the Director General. There was still no response. And we have had to go back to the the RTI Commission. So the information I requested in August 2020, we are now in September 2022, more than 2 years. We have gone back to the RTI Commission. This is the second time we are going back to the Commission on the same piece of information. A similar request to the local government and rural development, because they also did fumigation.
Manasseh, I was trying to find out whether in terms of going to the RTI Commission, petitioning them, do you have responses on those specific issues that you made reference to?
The response we had at the time was that the request had been sent to the Ghana Education Service. So the presidency didn't even get to the point. The RTI Commission actually wrote to them. And that was when they told us that, well, this is what has happened. And we even had letters from Osafo Mafo's office saying that the request had been sent to the Ghana Education Service. So we didn't even get to the point that the RTI Commission had to adjudicate or come out with a ruling. So that is it. But with the local government, they finally said that the documents have been submitted to the some for auditing. They didn't even tell us which institution was doing the auditing. Okay. So for that aspect, I will say that sometimes they try to play a lot of games, technicalities, just to dodge giving the information. Okay. But so
Manasseh, hold on for me for a second. Let me go to your colleague at the Fourth Estate, Evans Mensah. And Evans, I want you to give me a sense of the requests that have come from the Fourth Estate. I was going through the Right to Information Commission's website, and I realized that a number of the decisions that the Commission had rendered had been in respect of petitions that you had sent over there. Can you give us a sense of the number that had been sent from the Fourth Estate to various agencies, what the response has been, and what the challenges have been? I think you should unmute your device.
Can you hear me now?
Yes, I can hear you now. Go ahead.
Great. So we've been able to send to a few of the agencies about 133 RTI requests, and about 26 of those have ended up at the Commission for a determination. 5 of the requests we've made have been referred to other agencies to supply us with the information that we needed. And among the 26, the RTI Commission has given a determination on 17 of those that we've sent out. And what we've identified with some of the agencies is that, like Manasseh mentioned early on, they will take the request, they will act on it, and then when you write back to them, they will act on it as well. When you get to the Commission, it is then that they'll write to the Commission giving excuses as to why they were unable to supply you the information. And the Commission will now direct them to either give us the information or refer us to another agency in which custody the information we're requesting can be found. And I want to also commend, like Manasseh did, the Ghana Revenue Authority, the Internal Audit Agency, and the Ministry of Tourism for being responsive. And the Ministry of Finance. Some of these agencies have been very responsive in supplying the information that we needed to do our work. And that's what I can say as a preliminary commentary on this.
Evans, in terms of those who have not been responsive, I saw one decision. This is a petition you sent to the Right Information Commission involving the Ghana Police Service. And you had made a request to the Ghana Police Service. You wanted to know the budgetary allocations by the government of Ghana to the police service for the years 2013, 2014, 2015, 2016, up until 2020, the actual amounts that had been disbursed. And you sent this request first to the information officer, you subsequently sent it to the IGP, then it ended up at the Right to Information Commission. The Commission, just reading the conclusion here, the Commission ordered that they should provide the information within a certain number of days. Do you have this information?
No, we don't have the information as of yet. So that particular request has a lot of issues. When we sent the request even to the police service, initially they rejected the request, insisting that we need to address it to the chief staff officer instead of the information officer that the law requires us to do. Upon a few,
I mean, what reason did they give you for saying you should direct it to the chief staff officer?
They said they don't have any information officer at the Ghana Police Service, and so they can't take the request that we are making. And so they refer us back. We have to now go and write back to the chief staff officer, and then from there we appeal the request to the IGP. We had no response. Then we took the matter to the RTI Commission. They ruled on the matter, and they fined the police service actually. But still, as we speak, Joseph, we've still not been able to have access to the information. We wrote back to them, actually giving them the document that the RTI Commission decided on, and even the ruling, but they've still not gotten us the information that we needed to do our work.
I see. Let me come to Mr. Boateng at this point in time. I mean, are you surprised by what you are learning?
I'm learning for the first time that they haven't received the information. Because beyond our decision, we engaged with the Ghana Police Service, and it wasn't a difficult decision for them to give out the information. I think their challenge was the bureaucratic nature of their operations had made it difficult for them to even cite the letter at the time and the time limits required for giving out that information. So I think that I'll recommend that Evans makes an attempt to get the information. I'm sure he'll get it.
I mean, how is he supposed to make that attempt? He's done the attempt
because he
requires
process. The use of the information. He has come to the commission. We've made the orders. We've engaged with the police service. They are very open to giving that information out. And this is public record. I mean, what will it be to keep budget allocations away from the public? The challenge the police had indicated was they not getting the request on time to be able to address it. So I think they even engaged us to see if there was a way of waiving the penalties, which we couldn't do anything about. So they had earned the penalties anyway.
But it's not problematic.
For the inefficiencies in their system.
I'm reading your decision. You made specific orders directed at the Inspector General of Police. I mean, yes. Saying that based on the respondent's failure to make the decisions on the applicant's application lodged with it as well, you proceeded to say that within not later than 14 days. I mean, the gentleman...
We have the powers to make the orders. Now, enforcing it will require more than just the Right to Information Commission. You would have to take the court into consideration to get these orders enforced. But you see, we are a new agency. We are also in the process of establishing more regulations to help in the law's application. So you have to court these public agencies to comply until your regulations are in place, which would even give you further powers to exact the penalties out of their coffers. So it's an initial stage of the implementation of the law. Our focus is more on giving out, making sure applicants get the information. We are not too focused on the punishments. So at this point, our focus is how is Evans able to get the information in the current circumstances. As for the penalties, they continue to accrue interest until we are able to recover it. So it is in the interest of every public institution who has a penalty levied against them by the commission to go ahead and make payment. Otherwise, by the time we recover, they will probably lose their whole budget allocations. Yes.
I mean, the other issue that comes up from Evans's statement, I mean, under Section 3, the responsibility of public institutions in respect of access, they are supposed to have information officer or a designated officer of the public institution where a request to access information may be made. In this instance, they sent the request to titled information officer. They were told that send it to the chief staff officer because we don't even have an information officer. That is certainly irregular.
Yes, so we have been embarking on a public education exercise to ensure that public institutions become aware of their functions and their roles under the Right to Information law. Some are not aware that they even have to put in place an information unit and engage an information officer to perform these functions under the law. But the law also recognizes that in the circumstances where information officers are not in place, you can treat the head of institution as the information officer. So there not being an information officer shouldn't truncate the process of applying or requesting for information. Like I said, the focus is on how you get information. So we will not place too much emphasis on the form, but we will consider the substance or the end. The fact that you are looking for information and the processes are such that you should get the information.
Let me bring in Dr. Theodora Agentete. Doc has been looking at how this particular law has been implemented so far. Doc, what has been what you've been able to discover in terms of implementation.
Sorry about that. Thanks for the opportunity. And maybe before I say what I intend saying, I need to acknowledge the Star Ghana Foundation for initiating this particular report that I worked on. And I must say that after the initial draft was prepared, we had some form of engagement with the RTI Commission, and they've been quite responsive. But listening to Manasseh, listening to Evans, I get the sense that what we found, are the reality anyway. So some of the challenges, particularly when it comes to the subnational agencies, as I think Evans mentioned, so the district assemblies and so on, it's quite difficult to get information from there because a lot of the time they feel that they need clearance from, headquarters or the main ministry in order to, so that once the go-ahead is given, then they can give that information. But we should also note that if the response from the ministry says don't, then they are likely going to comply with the don't give the information. So that is one challenge there. It seems, and I spoke to a number of civil society actors, they get the impression that public officials, especially, let me say, public servants, are stuck to their old ways of doing things. You go into office, you swear oath of secrecy and confidentiality. So those things are really a major impediment to, access information. And then I'm happy Evans mentioned the information officers. It's one of the things that we found that because there are no information officers, a lot of the time, the process becomes slow. And one question that keeps coming to mind is who, and listening to Mr. Sapon-Boateng, he talks about the head of the institution being in a position, who can act as information officer if there isn't any information officer. And the question of who qualifies to be information officer is something that we really need to look at, because in one of our engagements, I think Mr. Sapon-Boateng was there, and that question came up, that who qualifies to be information officer? Is it just anybody? There should be a criteria, a clear-cut criteria for public institutions so that they know that this is the kind of person that I need to put there, and then they can comply with that.
Okay, I mean, specifically, let me take section 3 again. It states here that a public institution shall, within 12 months from the date of the coming into force of this act, and every 12 months after the date, compile and publish an up-to-date information in the form of a manual. So if you go to the D, it indicates that the name, address, and any other contact details of the information officer or a designated officer of the public institution where a request to access information may be made. I'm not too sure whether this has even been done by the various agencies.
So in the early parts of this year, the Right to Information Commission put together guidelines for the publication of information manuals by public institutions. And we have distributed it across public institutions, whether regional, district, or national, for these agencies to be guided by, to put together their information manuals. In fact, most of the agencies have put together their information manuals. Like I said, it's early days yet in the implementation of the law. We are pushing and courting public agencies to comply so that we have more people, more institutions complying with the law than those who may be against the contents of the law. I recall that Ministry of Health, for instance, put together an information manual. They actually had a ceremony to outdoor it. Similarly, Gridco has written to us, provided us the draft of their information manual, even asked us to help them streamline it, which we have. So there are some agencies who have taken the bold step in complying with what the law requires them to do. So I should expect that over the next year, when we are putting together our annual report, the numbers compared to the previous year would have increased.
I guess that would apply to the setting up of the information units as well.
Yes, setting up of an information unit. Usually what you would have public institutions come up with is that it wasn't part of their budget. So it's very difficult to find funding for that arrangement. But the law also has room for you to put in place a designated officer so that the person could be occupying double roles in the organization, and that he also acts as an
just to ensure that there's someone
who takes, yes. So for those who do not have information officers, it takes nothing away from them to put in place a designated officer who would be acting as an information officer. Like I said, the focus is on making sure information is delivered to an applicant. So whatever it takes, we are focused on that arrangement.
I mean, if you look at Section 19 of the Right to Information Act, it says that an application to access information shall be dealt with by the information officer of the public institution. I mean, Doc was making the point that in some instances, especially the agencies, especially outside the capital, when they make requests, they tend to be calling to try and find out whether I should give the information or not.
You know, the general Ghanaian attitude, I know there are exceptions, that we hardly read. So it's very difficult for public agencies to even know the content of the Right to Information Law and what it requires of them. So sometimes it takes us to proactively get them to appreciate what the law is about. We've been embarking on a regional sensitization exercise where we invite all heads of public agencies within the districts and the regions to appreciate what the law is about. So far, we've done about 10 regions due to budgetary constraints, but we are still in the process of engaging the regional level public institutions. The aim is to help them appreciate what the law is about and help in its implementation. And I believe it's only through education that we can achieve anything under the Right to Information Law. So it's something we are constantly doing. And I believe this, your platform you're giving us, is also an opportunity for us to reach out to people in public offices who have control over information, to understand that, for instance, when they keep saying the oath of secrecy that is taken by public officers impedes the delivery of access to information. The Right to Information Law, for instance, makes it clear that this law overrides any law that has to do with the disclosure of information. So it overrides the Oath of Secrecy Act, the State Secrets Act. So long as this law does not exempt the disclosure.
So if there should be any exemption, it should be still under this
particular law. So this law has come to help in the delivery of information, provided the law does not exempt that information. And that's what we keep doing to educate the public.
I mean, let me bring in Ben Boakye of the African Center for Energy Policy. I know that they were trying to get information. I saw one about the relocation of the Ameri power plant, if I recall correctly. I mean, is your story any different from what Evans and Manasseh and Doc have been sharing with us?
No, I think similar experiences where you have state institutions deliberately stonewalling access to information, even when they may have them. So, I mean, in our experience, we don't have as many requests as Manasseh and the Fourth Estate would have done by now. We have done 4. And I can say that, I mean, the law is working to a very great extent. You have at least the powers to request for information. And we have seen some of the agencies respond appropriately. The Energy Ministry did not respond to our request, but we were able to request for similar information from the Attorney General, who responded within a reasonable time, even though it lapsed the prescribed time frame within law. We had others like PPA who would also demand atrocious amounts for the provision of the information, even though we stated clearly that we needed the information through email. Okay, and therefore, if you are requesting us to pay 1,000 cedis for the information, we did not see why they needed to do that. So we have not yet, gone to the commission, but it looks likely that we would have to go to the commission for the commission to intervene in some of the applications that we have actually made. But I think, I mean, listening to the experiences that others are sharing, I think it's because the responsibility or the sanctions are really on the state and not the individuals who are deliberately stonewalling, and who may, of course, have interest in your access to that information that you are requesting of them. And maybe thinking through what we need to do will be, how do we get people, individuals, liable for not providing, the information that are requested of them. I mean, some of the agencies, even if you charge them 1 million, 10 million, because it's the state that is paying, they don't really care. They can pay the money as long as they can delay you access to the information until the transaction is done, until the state is changed, for example, and at which point, the state has lost on both, ends, whether it's a sanction or, the committal of the offense that could have been avoided in the first instance. So I think we have to think through how people can be held accountable individually for not providing information that could perhaps save the state some challenges.
I mean, let me bring Evans back before I come to Mr. Boateng, because I just want to, go a bit. There are two issues he raises. The first has to do with the fees that they had been asked, and the second one had to do with holding individuals accountable. So I'll come to you on those two issues. But I'm bringing in Evans because there was a request that was sent from Evans. You sent to the Minerals Commission, and they had wanted you to pay $1,000 to get that access to that information. You took it to the Right to Information Commission, and that was set aside. I mean, you're supposed to pay, I think, about 1 cedi 80 pesos, multiplied by the number of pages of information to be printed, or 1 cedi 90 pesos. Did you eventually access this information?
No, Joseph. The issue went to the High Court after a ruling from the RTI Commission. And the Minerals Commission again went to the Appeals Court to have a review of the decision by the High Court. And so that's where we are now in the process. I
see. I mean, let me come to you, Mr. Boateng. In that particular decision that you rendered, you had made a point that you were trying to engage Parliament in terms of the fees to get it in place. I mean, has that been done?
So I have some good news for applicants for information. The Fees and Charges Act, Miscellaneous Provisions, Act 1080/2022 has just been passed. And if you go to the last schedules of the Act, you see revenue item under the Right to Information Commission, which refers to the charges that applicants are supposed to pay in every public institution. So now there's clarity. We now have the Fees and Charges Act and charges that agencies are supposed to charge for the kind of information people request for. If, with your kind permission,
go ahead.
If I may go ahead. It says, for every photocopy of an A4 paper or part thereof, you pay 27 pesos. For every printed copy of an A4 size page or part thereof held on a computer or in an electronic or machine readable form, you pay 38 pesos. For a copy in a computer readable form or on an external storage device, you pay 29 pesos. For a transcription of visual image for an A4 size page or part thereof, you pay 1 cedi 28 pesos. For a copy of visual images, you pay 3 cedi 50 pesos. For a transcription of an audio record for an A4 size page or part thereof, you pay 70 pesos. Then for a copy of an audio record, you pay 1 cedi. So if you even consider what the state has approved, what we had ordered in that case were even quite a little higher.
Yeah.
So it sits with our argument that the fees ought to be reasonable in respect of the reproduction, not for the cost of generating the information. And that's what we want to sound clear to every public institution. And now you can't just say 1,000 cedis in the case of Mr. Boateng when they requested for information. They, as applicants, can now have access to this Fees and Charges Act, which spells out the fees that they are supposed to pay. So there's clarity. And no agency can just come up with any
outrageous amount like the $1,000.
Exactly. So now there's clarity. But even in the absence of clarity, I think the courts were bold to endorse what the Right to Information Commission did. That if Parliament has decided not to act, the power sits with us to do what is reasonable and just in the circumstances, which the Commission did anyway. So in terms of fees, now there's clarity. I think we arm our applicants to still now have more power to ask for what they are looking for, knowing how much they are to be charged. Right? So the Fees and Charges Act 2022, Act 1080. Act 1080 solves that problem. Now, Mr. Bwemboachi spoke about how we are able to get individuals to be held responsible.
Yes.
There are offenses that have been created by the Right to Information Law. If you look at section 81 and 82 of the Right to Information Law, you realize that these offenses are not created against the agency. It is created against the individuals who are responsible for giving out information. So we should know that the law has made provisions for people under the regime to be punished personally. Because if you have to go to jail, the agency is not responsible for going to jail. It's the individual who had a function or a role to play under the Right to Information Act. Now, that notwithstanding, you would recall that we will slap some penalty on an agency.
Yeah.
And of course, if the agency has the power to pay, then they really don't care. In
fact, one of them that I came across, ADB, you asked them to pay 300,000 cedis.
Yes.
This was, they also supposed to, it has to do with a request that had come from the Center for Democratic Empowerment. And you said, I mean, quoting from the decision, the Right to Information Commission finds it intriguingly curious the level of resistance mounted against an application for the release of information. And so, I mean, I read the decision, they were effectively challenging your authority all over, including questioning how it sits in the face of the Public Procurement Act, among other laws.
Yes, we considered all their challenges in coming to that conclusion, but it helps to develop the law. So we are in court with them. We allow the court to make its decisions. But it's just for...
They are seeking to set this aside.
Exactly. It's just for the application of... it's just for the individual citizens of this country to hold public institutions accountable. So if you have information which you generate for and on their behalf, then why can't we ask you to give out that information? ADB's contention is that it is not a public body or a public institution as anticipated by this law. It is a different kind of institution according to them. But if you go to section 84 of the Right to Information Law, all right, the interpretation sections, it defines what a public institution is. It says a public institution includes a private institution or a private organization that receives public resources or provides a public function. It's simple. So the question you would ask yourself, whether you are covered by this law, is first of all, do you provide a public function? If the answer is in the affirmative, then the law applies to you. Or do you receive public resources? If it is in the affirmative, then the law applies to you.
And in that particular decision, you said that the respondent performs a public function because its banking services or activities benefit the bulk of the Ghanaian public with a special emphasis and focus on agriculture. Indeed, a simple visit to their website shows this as part of the respondent's profile.
Exactly my point. So it's not for them to scream, we are not covered. It's for you to actually read the law and see whether the law covers you. This is not a law we created. It's the law passed by the Parliament of Ghana and under our 1992 Constitution. So this is what it is.
I mean, but the point that, I mean, Mr. Boachi was raising, I mean, it means that if I'm to understand, you've not started going into Section 81 and 82 yet. You've not started implementing those ones.
So let me come to section. Let me finish what Mr. Bwemboachi had indicated. Now, I indicated that some public institutions may have the wherewithal to pay these fines, and therefore they will rather err and pay the fine than perform the function under the Act. We had an engagement with the Auditor General, the Deputy Auditor General, where we had indicated to the Auditor General that, you know what, consider right to information obligations and the infractions that people may make when you are doing your work. Now, if by any means, any public officer whose function it was to perform a function under this Act failed and has cost an institution some penalties, we implore you to surcharge such individuals with the losses that they may have incurred on the agencies, all right, which they have agreed. So it is not enough to say, well, the agency can pay. You must also realize that it gets to the point where you may be surcharged to pay what you let the agency lose. So that arrangement, we have pushed the Auditor General to agree with us that that's something they ought to be doing. Now, under Section 81 and 82, you had just indicated that we may not have started
because, I mean, under 82, it says a failure or neglect by an information officer or other public officer to perform a function authorized by this Act where the occasion arises to perform that function constitutes a gross misconduct, and 2, a person who seeks or gains access to, so it goes under.
Yeah, so more offences created under 81 and 82. As the Right to Information Commission, we recognized the task that the Attorney General has in terms of prosecutions. They have too many offences to prosecute. That's why you realize that they have designated some of their powers to the police to do some prosecutions.
Among others.
IOCO, among others, the Special Prosecutor's Office. We applied to the Attorney General to give us some power to prosecute offences created by this law. And he was magnanimous enough to grant us that fiat. They are yet to issue the executive instrument, making us able to prosecute these offences. But in principle, he has agreed. He has also given us officers to train officers at the Right to Information Commission to become prosecutors for the prosecution of such offences. So what it takes to actually kick the ground running, we have already set the tone. And very soon, offenders under the Act will have questions to answer with Right to Information Commission officers prosecuting these offences. It's a gradual stage, but I can assure you that this Right to Information Commission you have is poised to discharge its functions under the Right to Information law.
In terms of penalty recoveries, I mean, what's the plan going forward? So
we have an LI coming up, a legislative instrument, which more or less is the regulations of the Act. What it seeks to do is to aid us recover money from your bank account just by an application to court, okay, when you have failed to make payments to us. So it's our focus and our hope that the process of getting this LI passed will even make agencies sit up in terms of their deliverables under the Right to Information law. Otherwise, you have us to deal with. And we are a very young agency looking for funding to carry out our mandate. So if you give us the opportunity to take what you have, we are happy. We are happy.
I see. I mean, let me bring in Benjamin Darko. He is with the Fix the Country group. Benjamin, I know you guys are trying to get some information from the Ghana Police Service. I mean, was that something you were able to get access to?
Thanks for having me. We couldn't so far. I think of all the agencies we've written to so far, it's a police service that have a low response rate, basically 0. They don't respond at all to any requests I send to them. They don't issue receipts for having your letters. They don't respond to mails, basically. So it's been 0 so far. And we've sent those complaints to the commission for review. So we'll be waiting on the commission to get back to us, and then we'll carry the issue forward.
And so, I mean, it appears that you are not, but you did indicate that there are some other agencies that are complying and giving information. That's correct, right?
Yeah, so far we've sent about 18 requests. We've had 6 responses in. We've sent about 9 to the commission. Out of that, we've had about 4 they responded to. So I think all in all, the commission has been extremely helpful. When you send a review to them, mostly you get your responses on time, and they're able to press forward and then get you the particular information that you're requesting for. So they've been so helpful, and the work that they are doing over there is a bit massive. We are grateful for the law that was being passed, because previously you couldn't write to an agency just to request for information. You're not going to get it. So I agree fully well with what Manasseh said, but I'm going to implore that some of the state institutions must do well to even place in the an officer who is in charge of giving out that information, because a huge ministry like the Ministry of Roads and Highways, I went there to go and submit an application for to go and submit a request, and I was sent to about 3 offices, and all in all, they had no one even to take that letter from me, because they told me there are no officer who's supposed to take those kind of requests and work on them. So a letter that was submitted about 8 months ago, I got a response like a month ago. It took a long time, and it makes our work a bit difficult, because sometimes you need the information to come in handy at that particular time that you're requesting for it. So we're going to plead that they work on our request with some speed, and then get to understand that this kind of things helps in shaping our democracy as a whole.
I see. I mean, someone sent a question. It says, but must the information requested by these guys attract any fees, since the information is in the public interest? I guess your response would be that it's for the production. of the information.
Okay, so if it's in the public interest, it is not for you to say it is in the public interest. You must lead evidence to support that arrangement. In other jurisdictions, you realize that it's not for nothing you see petitions being signed. It is to gather evidence that this is indeed in the public interest. But if it's just an individual who says it is in the public interest, the court will disagree with you, that you haven't shown that indeed what you are asking for is in the public interest. I think in one of the cases against the Ministry of Communications for some National Communications Authority, the journalist had indicated that their request was in the public interest. The court disagreed, that there was no evidence leading to that arrangement.
I mean, and the legal basis for that question that came in section 75(2)(c), it says an applicant seeking access to information under this act shall pay the fee or charge approved by Parliament in accordance with the Fees and Charges Act. But 2C says, despite subsection 1, a fee or charge shall not be payable for C, the reproduction of information which is in the public.
Yeah, I'm saying that, yes, there are fees to be paid, but two circumstances under which you should not pay fees. For instance, is when the information is your personal information. The law says you are not entitled to pay fees for that. And then when it is in the public interest, you are not entitled to pay fees. Now, the issue of public interest is a matter of law and evidence. It is not for you to just say what I'm asking for is in the public interest. That's all I'm trying to say. So if you go to an institution to make a request and you just say it is in the public interest and you haven't shown evidence to that effect, then you cannot get that information for free. You may have to pay the fees approved by Parliament. And like I said, God being good, the fees are out. Yeah. So now this halabaloo about the absence of fees regime, all right, is over. We can all refer to what fees we are entitled to pay for the kind of information we are asking for. And it's even cheaper than we anticipated. Sure.
Okay, so now what we'll do is that I'm going to go around Manasseh, Evans, Mr. Boakye, Doc. I mean, if there are any specific questions or specific issues that you want to raise with Mr. Boateng, I'll start with Manasseh.
Okay, I want to raise an issue with the fees because we have an experience with some state institutions that decide unreasonably the form in which the information is submitted. We know that they have the information in soft copy, yet they insist that they will give it to us in a printed format. And when that happens, it defeats sometimes the purpose for which you're asking for the information. It makes it difficult to even work with it. And two, it makes it even more expensive. Let me give an example. We applied to the Scholarship Secretariat and also the one other institution. And they insist on giving it to us in a printed copy. And let me give a bigger example. So if I want to apply to the Electoral Commission to give me the register of voters, and the Electoral Commission, instead of giving it to me in a soft copy, insists that they are going to give it to me in a printed format. And then they have millions of, about 15 million. And I'm even to pay 20 pesos per copy. That is going to be impossible to pay, and it may also be impossible to even work with the data when I have it.
Okay.
The question I want to ask is, what is the commission doing, or how are we going to find a way around it? Because state institutions are going to use this, and they have started using it. We at the Fourth Estate have 2 examples already.
Okay.
I want to also end by commending the RTI Commission very highly. I was very skeptical when they started their work, but they have proven me wrong, and I pray that they continue to do it this way. Okay. And perhaps expedite actions in sometimes the complaints that come to them, because we have a complaint against the presidency on this private jet issue, and we think it has taken too long for us to get a response. Otherwise, I think they are doing a very fantastic job. And I commend them and hope they continue this way.
Okay. So, I mean, first on the fees issue.
Yeah, the fees issue. I think that he has a basis for that fear that some will insist that they will give it to you in the form.
I can't imagine for the voters register.
Yeah, in the form they are they want to give to you just because they know it's going to be expensive for you to pay for. Now, what I would encourage applicants to do is that if you are of the view that the information you are requesting is in the form you want, other than what they insist they want to give it to you, all right, the commission is open. All right, we have powers to inspect the form in which information is even held. All right, we have powers to order it and be sure that this can be done in this way. So why are you insisting you only want to do it this way? Okay. We shouldn't only leave it to, yes, a decision has been made by the commission, you should give us the information and allow it to be. But if you are of the suspicion that, look, this information you are looking for is actually in soft copy and it can be given to us in soft copy, come to the commission, we'll take steps to inspect that information and let you have it, because we have the power to do so. Okay. And these are powers which will help people get information they are looking for. Okay. So maybe applicants for information should also arm themselves with this information.
Well. I mean, the other issue says you guys are taking
yes, I think that we should be fair to the commission. Some have indicated that we act very fast and even help institutions to get them the information as soon as possible.
I mean, but what's accounting for the delay in
so when a matter comes before you, you actually investigate. Investigations doesn't mean listening to one side of a matter.
I mean, you have to give a fair hearing.
Sometimes you even listen to people who are not even parties to the matter to appreciate the issues that are up for determination. So we should be fair to the commission. What we are interested in is not the speed with which we come out with decisions. It is making sure we make decisions that will move this country forward. So I think that I would encourage all applicants to be patient. The law, it's not for nothing that the law doesn't put time limits on decisions we make.
But I realize that when you are making your request for the response from, you tend to put timelines on it.
But it's our discretion. We decide how far to go. Now, remember that this issue about private jets and others, it's not the first time, and it's not the first time that it's coming to us. These are questions that people have asked so many agencies, all right? So if you want to come to a conclusive determination, you must consult all these agencies to come up with reasons. The Right to Information Commission is not clothed with all the knowledge when it comes to information. Okay. We do research as well, okay. All right? So we should be patient with the commission. Okay. Whatever decision we come up with, it will be in the interest of the Republic of Ghana, okay. Right? The thing about applicants and journalists for that matter is that when the decision seems to be in their favor, so excited. But when it goes against them, they don't even talk about it. So you have this editorial discretion. You choose which one to talk about. But sometimes there's more education in the ones that we have refused.
Yes, people can understand what type of information.
So I also encourage them to put out those decisions.
Yeah, but I realize you guys publish the decisions. I think you should publish it.
Yeah, we publish the decisions all the time.
Yes.
Yeah, to make it, I mean, we won't wait for someone to come and request for that. Yeah. For us, our argument is that we should all be proactive in putting out information. If I can give this information to A, then I should be able to give it to everyone.
Everyone, yeah.
So if I give it to you, I'll publish it. So that when another person comes for that similar information, we can only refer you to where it's available.
I mean, Doc, any specific concern or question that you have for Mr. Boateng?
Thank you very much. I also want to add my voice to say a big thank you to the RTI Commission. In fact, their interventions have been very instrumental in making sure that the law actually works. And when you look back before they were put in place versus now, you can see significant difference. I also want to say that the media, particularly, I must say, the fourth estate has also been very, very instrumental in making we call it testing the law. I think that they are, the regular requests for information and all of that have been very, very useful for us to know the challenges that people are likely to encounter and all of that. But I also want to say that it looks to me that in terms of trends of requests, they are mainly coming from CSOs and then the media. And I think that I know the RTI Commission, I follow them keenly. They are doing so well with their public education campaigns. I think that generally, in terms of advocacy and campaigns, we should be looking at educating people on why it is important to use the law and not just knowing about the law. I think it's very important. a question that I have for Mr. Sapong Boateng is, when I was doing the study, I got to know that the Ministry of Information is deploying an ICT system to, among other things, track RTI requests or to see the flow of, requests and all of that. May I know whether you know the status of the system and how the Commission is benefiting from such a system? Thank you.
You answered that. I'll take the final one from Mr. Boache, then I'll come to Mr. Boateng for the response.
Thanks. A quick one. I think the Commission is doing well. What I want to find out, given that they have a lot on their plate, would they want to prioritize some of the institutions to guide them on the processes for meeting RTI requests so that they can properly set up to administer that responsibility? I do recognize that even though all institutions are important, but we can prioritize them so that we take those who are taking bigger decisions, like Ministry of Finance, Ministry of Energy, and those who are engaging. Because we do know that most of these applications will be around procurement, and some of these agencies need to set up quickly for us to protect the interest of the public and the financial position of the country. Maybe to prioritize that. And also with the private sector agencies that are dealing with government, maybe we need to have a conversation with the private sector at this point as a form of education, so that when the request starts going through, they will not be wondering whether they are part of this whole structure or not. I think prior engagement with the private sector will also be relevant from the Commission. Okay,
sure. I mean, I'll take your responses very briefly, then we'll talk about the RTI week.
Okay. So the ICT arrangement that the Ministry of Information is deploying, I think it's commendable to the extent that it is not only to track requests, it's also to make it easy for people to access information. So they have engaged with us to explain to us what that arrangement is. And it is to help public agencies meet RTI requests. Okay. So I think that is a commendable arrangement that we need to support to have it in place. Hitherto our agencies have kept records in the hard copy or in hard form. Yeah. And it's difficult to even trace documents when people come up with requests. Okay. So the Information Ministry, which we don't fall under, but we collaborate to ensure that this whole space is well adjudicated, came up with that arrangement to help public institutions store their information in a certain form and make it easier for people to access that information. Okay. Yeah, so yes, we are in the know, and then we know how it's going. They don't require our approval to do that, but they collaborate with us to let us know that these are some of the things they are doing to help the space. Okay. I think that the recommendation that we should prioritize certain agencies is in order from Mr. Boache, and we'll consider that in our monitoring exercise to help these agencies meet the requests that are coming from the public. Because obviously, Ministry of Finance will receive more requests than any other agency. Yeah. And I must say that they have a very good... Ministry of Finance is one of the agencies that has really set
I sent a request there. They gave it to me within the 14 days.
Exactly. They have taken it very seriously and they are doing very well. Okay. There's a young lady who runs their information department. And I think that she deserves some kind of mention. Yes. Is it Lovelace? There's a lady by name Lovelace. She's doing very well. When she has challenges, she comes to the Commission to be educated, and then she goes about it that way.
Great. I mean, we're almost running out of time, so I just want you to have the final word on the
Right to Information Week.
Yes.
Yes. As part of the marking of the International Day for the Universal Access to Information, which is recognized by the United Nations annually, we put together a Right to Information Week, which we will mark every year. Last year we marked it. This year we are yet to mark it finally on. This afternoon, we were at the GBC studio to have What Do You Know exercise with National Service personnel participating, competing on the knowledge of the Right to Information Law. Tomorrow, Monday, we have a stakeholder conference, which would include the media, CSOs, and other persons who are interested in the Right to Information Law. I'd invite all our panelists who joined us online to make an attempt to be part of that arrangement. Let's discuss the progress we have made. Let's discuss the challenges that we have. And let's see the way forward in putting together an arrangement that works for the whole nation. Okay. On Wednesday, we'll sum it up with the marking of the International Day for the Universal Access to Information, which is recognized every 28th day of December every year. This year, the theme is on artificial intelligence, e-governance, and access to information. Yes. We want to encourage this nation to redirect its education towards artificial intelligence and e-governance. And I believe it will help in the discharge of our functions under the right to information law.
Okay, thank you very much, Mr. Sapon Boateng, Executive Secretary of the RTI Commission. That's all time will allow us. This has been another edition of The Law. I am Joseph Ackah-Blay.